The last 2 times that I reported for jury duty, I got kicked by attorneys using peremptory challenges. The first time, a criminal case, I was working on post-conviction record relief. I think that made me a prosecutor's worst possible juror. The second time, I held a more general legal position, and it was a civil case. So there wasn't necessarily an identifiable reason not to have me on the jury. But voir dire is basically vibes-based decision-making. It's neither an art nor really a science. And I think for me that both times it boiled down to me getting kicked because I'm an attorney. And, well, attorneys don't think other attorneys make good jurors. But being an attorney doesn't place me in some kind of protected class. So it's totally kosher to keep us off of juries, as long as we're kicked for our profession and not our race, gender, religion, or a handful of other protected categories. In the prosecution of Sergeant Thomas, a case that implicated race, gender, and religion, the art of panel selection spawned a lot of creative interpretation. This is Conduct Unbecoming. I'm Erin, and I'm your host. We have had such a string of discomforting details in cases, so I thought I would perhaps focus on one that didn't necessitate the discussion of physical assault. No disclaimer needed in today's episode. I think the case I chose was the right call for a couple of reasons. First, as I mentioned at the top, I think it's the right call because we've had such a series of unpleasant cases. I didn't want to talk deeply about sexual assault or physical assault in today's episode. But the second reason I chose this case is that I think it plugs into a broader conversation that we are having or should be having in this country. By now, many of you have probably heard the news that the Department of Defense is looking at ways to revert to names for military installations that were deemed controversial or racist under the previous administration. They want to spend more money stripping the base of less controversial names and return them to their racist origins. You've probably already figured out how I feel about it. I'm not persuaded by this concept that we need to hold on to racist ideas and racist people in the name of history. No one would accuse me of being shy about the fact that I believe we should consign racists and Confederates and traitors to this nation to history books, and not revere them enough to emblazon their name across military installations. I do think there's probably something to be said for the idea that perhaps when the bases were named originally, people didn't know any better. I don't think it's a realistic defense because many of the things named in the 60s, for instance, were a direct reaction to the civil rights movement, an effort to tell Black Americans where their place was. I would really love to believe that people do the best that they can until they know better. But the thing about that is that it actually requires committing to doing better once we know better. We don't live in a post-racist United States. The hate is still there. It's still lingering. And unless we call that racism out, and we move away from restoring Confederate names to bases, for instance, I don't think we can reasonably say that we've done better, that we're doing better. The United States military is one of the most diverse employers in the United States. But beyond that, they have the caretaking responsibility of this nation that is not exclusively white, this nation that is not exclusively men. So I would like to believe that we prioritize representation and the actual protection of all Americans. You might be wondering how I can possibly tie this episode into that conversation around race in the United States. So I think it's time to turn to Sergeant Ryan Thomas. Thomas got himself into a spot of hot water while he was stationed at Fort Stewart. Following a spate of terrible decisions, Thomas pled guilty to one specification of failing to obey a general regulation and one specification of adultery. That didn't dispose of all the charges he faced, and Thomas elected to take the balance of his charges to contested court-martial before a mixed panel of officers and enlisted soldiers. The remaining charges included specifications of cruelty and maltreatment and the sexual assault of his stepdaughter. I know I told you I wasn't talking about disclaimer-worthy behavior today. Even though Thomas faced those charges, I'm confident we have enough to talk about that we can turn away from the details of how Thomas's actions came to light by focusing on the final category of charged conduct, consisting of multiple specifications of wrongfully making derogatory statements regarding race. It was alleged both that Thomas used racist and derogatory statements around other soldiers and that Thomas maltreated subordinates by making offensive statements regarding women and religion. In preparation for weighing Thomas's guilt or innocence, a pool of potential panel members paraded into the courtroom. They answered questions designed to get at whether they might possibly be able to approach the variety of charges Thomas was contesting and not be biased. They were asked about their views on racist and derogatory language, and the attorneys inquired whether they had ever been affected by racist language. To assist the voir dire process, there was some kind of paper aid that listed, as best I can tell, the comments or sorts of comments Thomas was accused of making. A footnote in a brief reveals the most inflammatory comment was Thomas's use of the N-word. This is probably the right time to note that Thomas is white. 6 panel members revealed that they themselves or someone they knew had been subject to racially discriminatory language, gender-biased language, or religion-motivated language. First up, a colonel and a lieutenant colonel. The colonel described being on the receiving end of racist comments, including a derogatory epithet often directed towards people of Chinese descent. He elaborated that the last time he was referred to by the offensive name was 32 years earlier when he was a teenager. He assured the court that he would be fair and impartial. The lieutenant colonel, who identified as multiracial, had more recent experiences, though he reviewed the flyer and said no one had ever looked him in the eyes and used words like that. He stated that hearing those comments or jokes that used similar language got him charged, but that his previous experiences wouldn't taint his perception of the case or hinder his ability to be impartial. A major that we'll use the phonetic alphabet to refer to as Major Kilo similarly indicated that he or someone he knew had been subjected to discriminatory or biased language. You see, Major Kilo was black and grew up in Germany, near a town that he described as having the largest neo-Nazi presence in the country. I do wonder whether that's more or less than some American cities. Living there, he encountered discrimination just by going about his day-to-day life. And even after he grew up and joined the Army, he was referred to as the N-word at the Joint Readiness Training Center in Louisiana. But Major Kilo didn't jump to judgment of those who used such a word. Instead, he had taken into account whether the racism impacted him professionally, who was making the comment, where that person came from, the context they used the word in, and whether their intent was derogatory. He said he could even find it acceptable for a white person to use the N-word in certain circumstances. He took the approach of ignoring the slurs and moving on, believing that slurs were just a part of life and you have to move through and past them without worrying about a lasting emotional effect. 2 other panel members disclosed their respective issues related to race. The first shared that he believed someone who would make a joke involving race, religion, or gender was automatically hostile towards that particular group. The second disclosed that he, a friend, or a family member had been the victim of a race or gender-motivated crime. When conducting voir dire, that is, selecting a panel or a jury, both sides get to decline to seat jurors without real explanation. These are called peremptory challenges. Peremptory challenges, or strikes, are different than someone being released from jury duty for cause. I've seen jurors released for cause because they had prepaid vacations during the trial, they weren't fluent English speakers, or they disclosed that they could not be impartial for whatever reason. Evaluating whoever's left, the parties can spend their finite peremptory challenges. It's important to note that the strikes are limited. You can't just keep vetoing panel members ad nauseum because neither side will be happy with the ideal panel or jury that the other side is looking for. I have very little to go on in this case, but I think the government and defense each got a single peremptory challenge. So, while they were conducting their voir dire, Thomas's counsel challenged the panel member that said he would assume someone who makes racist jokes was hostile towards people in that racial group. He was dismissed for cause. They also challenged the man who disclosed an incident of race or gender-motivated crime that had impacted his life in some way. He was also dismissed for cause. They successfully made 2 additional challenges for cause and used their peremptory challenge. The government used its peremptory strike on Major Kilo. Hearing that, defense counsel asked for the facially neutral basis for the government's decision, under Batson. Batson provides a boundary, a limit to the ability to boot jurors. As relevant here, the parties can't bounce a juror based on their race. So if a party uses a strike that doesn't quite sit well, the other side can request a reason. Using myself as an example, a neutral reason would be something like, oh, well, I've had attorneys on the jury before and it was miserable. But it would be unacceptable to provide the reason, I don't like to have women on the jury. Government counsel explained that they were concerned about Major Kilo's minimization of the impact of racist language. And counsel believed that Major Kilo possessed the attitude that if he could endure racism, then anyone else could as well. Defense counsel conceded that was a facially neutral reason, but then called it a facade to cover up their real intent. Without much explanation, the judge found the government counsel provided a facially neutral reason and granted the peremptory challenge, kicking Major Kilo. But after the members were impaneled, Thomas's defense made a motion to dismiss. They specifically challenged charge number 2 that housed all those language-based offenses. And again, this was after the panel was selected and seated, after all that back and forth about whether potential panel members experienced sexism or racism. After all of that, defense moved to dismiss the charge for a failure to state an offense. And the military judge agreed. Although it might be morally and ethically abhorrent for Thomas to use racist and sexist language, or language attacking specific religions, it apparently wasn't a crime under the UCMJ. So the military judge dismissed the second charge. And that's why I think this case matters so much. why it is necessary to spend this episode talking about what Thomas did or was alleged to have done. Because where it is not illegal, but rather only immoral to use racist slurs and derogatory language and to insult women and people of certain faiths, racism, sexism, and other isms flourish. That creates an environment in which it is acceptable to hate. I don't offer that with the hope that we make it illegal to use those words, but rather categorically unacceptable. We know better than to name military installations after people who embraced racism, sexism, and other forms of discrimination, and we owe that diverse service member population more. Service members who've signed on to protect this country against all enemies, foreign and domestic, deserve better. They deserve to walk onto a military installation and know that the person or people that it was named after viewed them as a whole person, and would have treated them with the respect they were due. After some COVID-related delays, the court-martial resumed, and the government noticed defense that they still intended to offer evidence that Thomas made offensive and derogatory remarks about women and racial minorities, because it went to his intent as to the maltreatment of his subordinates. The following month, Thomas moved for a mistrial, citing the panel's exposure to his alleged inflammatory language during voir dire. The military judge denied that motion and proceeded to his court-martial. The panel found Thomas guilty of 2 specifications of cruelty and maltreatment and 2 specifications of sexual assault of a child. I believe that means they acquitted him of 1 specification of sexual assault. In accordance with his convictions, inclusive of his earlier plea, the panel sentenced Thomas to confinement for 8 years and a dishonorable discharge. On appeal, Thomas challenged whether the military judge abused her discretion when she denied his motion for a mistrial, and whether she erred by admitting prior consistent statements from his stepdaughter. The Army Court of Criminal Appeals got their hands on Thomas's brief and the record and floated a question to both sides, inquiring whether the military judge erred in denying Thomas's Batson challenge to Major Kilo. They got all that responsive briefing back, and then the ACCA concluded that the judge did not err in denying Thomas's Batson challenge, although one of the judges did dissent. The dissent highlighted that it seemed Major Kilo was the only black panel member, and that he received more specific questions than the other soldiers. The explanation the government provided, the dissent reasoned, those explanations were still focused on race, and the judge was displeased with the lack of development of the trial judge's reasoning, wanting more information about which of the reasons government counsel offered that the court found most pertinent. The opinion also highlighted that Major Kilo made clear that he was able to neutrally consider a racist comment without judging the speaker prematurely, and honed in on Major Kilo's constitutional right to not be excluded from the panel on the basis of his race. That all lands with me, but it seems to me like there's some friction in the logic around whether the government's reasoning was still race-based. Government counsel expressed concern that Major Kilo's grin-and-bear-it sort of attitude towards racism might mean that he expects others subject to slurs to similarly move on. And the rub there is that only someone who has experienced racism can really hold an attitude like that. But if this was a sexual harassment case, and a juror came in and said that she had been sexually harassed but got over it and expected other victims to also get over it, would we consider dismissing that juror because of that attitude to be a gender-neutral reason? I think we would, but I question whether that is because men are also sexually harassed. That is that in my hypothetical, there is no requirement that somebody be part of a marginalized group in order to hold the attitude or belief at issue here. And sure, there are words that can be used to insult white people, but I think we can agree that those insults don't rise to the same level, that they aren't slurs, that they don't have the same emotional impact. So I think the majority opinion got it right. Thomas disagreed and took his appeal to the Court of Appeal for the Armed Forces, who agreed that the ACCA got it right and declined to overturn the Tulloch standards, applying a modified version of Batson to courts-martial. As a practical matter, they implied it would be helpful for counsel and court to develop their reasoning and record more thoroughly. Thank you for listening. If you enjoyed today's episode, please share it. I invite you to submit case suggestions and feedback to conductandbecomingpod@gmail.com or on conductandbecomingpod.com. Join me next time when we discuss a Space Force guardian being more into the force than the guarding. Until then, take care. Conduct and Becoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct and Becoming is not approved, authorized, or endorsed by the Department of Defense.